So welcome everybody, and I'm pleased to be joined again this week by Ian Hull. And today we're going to, oh boy, no, there we go. Today we're going to talk about testamentary capacity issues, but specifically about what we as the drafting solicitors should be noting in our file, talking about the way we might want to interview our clients. Ian, as all of you know, is a preeminent state litigator. So we're going to get his insight on how he would deal with examinations, because whenever you draft a will, especially in a situation which is a little bit higher risk, you got to assume that you're going to be questioned on it, and so we're going to rely on some of his advice for that. So welcome, Ian.
Thanks, Jordy. Good to be back.
And so last week, Ian, we talked about specifically the impact of the situation that is facing the client. And how that impacts on the level of cognition that might be required, as well as the task that's being dealt with. So drafting a will is the broader kind of task, but then depending on what the instructions are, the task may become more complicated and therefore require a higher level of cognition, right?
Absolutely. And you know, one of the things that I struggle with is, and your opening comment is so true in the sense that when you do a will, and when I get to the point where, and I still draft wills, but when I get to the point where I'm attacking a lawyer or defending a lawyer for having done the will, I am always struck by the importance of even what we would have thought at the time to be an easy will, the importance of documenting it, because it ties to the situation specific. Just because the situation appears to you to be uncontroversial, young couple comes in, or a couple who's been married a long time comes in and just does a mirror will, gift over to kids. If you have a record of that, it's a meaningful record of that, it is still important. And it isn't sufficient when someone's going to come revisit this will situation to have just a simple two-line note that says gift over to each other, gift over to each other, and gift over to kids. And you know, I had a case literally last week where we have an important determination as to the likelihood of success of the case being tied to the third will that was done 20 years ago. And whether or not it was establishing a mirror will or a mutual will, and what notes were taken and what considerations were taken. And it was a situation-specific case where it was very simple. The couple had been married for 30 years, and they came in and literally gave instructions to gift over to each other and to their kids. I guess I just say that to come back to the importance of not taking any situation too lightly. And so a way to do that using technology is to document every time you do a will and you do will instructions. And the second point that I just wanted to start with, and happy to take it wherever you like, Jordy, but I prefer to ask the questions as opposed to you asking.
I've noticed that.
You're turning us around on me.
No, yeah,
and you know, and my dad always used to say this to me, you know, with will drafting, especially, always when I'm going to defend or attack a will, I'm always, the first thing you got to do is read the will. But second of all, he'd always say to me is, Ian, think like a lawyer, because, and that sort of sounds a bit vague, but if you think about it, when you're dealing with the question of testamentary capacity, it is actually important to think like a lawyer. Look at what are the codified restrictions or parameters that we need to consider when we're going to do a capacity assessment. And turning to that page, the criteria, of course, from Banks and Goodfellow are the parameters for wills, taking will instructions. And then just going back a couple slides, there's the presumption of capacity. And the fact that the statutory there's a statutory presumption of mental capacity set out in the Substitute Decisions Act itself. So these sources actually help draw me into my mindset when I'm looking at determining capacity. And remember, just because you litigate, you too have to, as a litigator, you're constantly assessing capacity of your clients as well. Maybe not testamentary, but capacity to instruct you as a counsel and so forth. So I like to always go back to those parameters that are actually codified and are established, to keep those as check marks, so that when someone says to me, well, did you consider, was he capable or she capable of understanding the act of making a will and its effect? Or the same question with the power of attorney, depending on what power of attorney you're doing. Again, as simple as it can be, it's always helpful for me to have started with the basics. So I keep these sort of bullet points close by when I'm going through the assessment, and I'm literally checking them off as I go along. But those are just some of my opening thoughts.
Well, thanks. I know it's always challenging for you to think like a lawyer. Rodney knew that was going to be a problem for you, but he stuck with you, and that's pretty impressive on his part. Let's go through this. So what are you going to say to your client to satisfy A, for example? Anything you want to, any note you want to make about that?
Well, I think that's, and it's A for a reason, because capable of understanding the act of making a will and its effects is something that I love to open with and to sort of tease out when I am taking instructions, to say, what do you want me to do for you? What is the nature of my retainer? And what is the nature of, as you understand it, the nature of my retainer, and what is going to be the impact of the work I do for you? And I know again, it sounds like a simple question to ask, but that's a great red flag. If people are coming in to sit down because they've been pulled into the situation by someone else, and they're like, actually, I'm not really sure why I'm here. I forget why.
That's what I ask is, so tell me why you're here. That is a good way, just a good opening for that kind of making a will kind of, I'm here to make a will. Oh, so what's, that kind of just opening discussion. And I think you're right. It also deals with, is somebody forcing you to be here or not? Right.
Yeah. And it's funny. Sorry, go ahead.
No, you go ahead, please.
My just last thought on that is that it's funny how the red flags, they come off the page. If you just ask in a casual and comfortable way questions that you'd want someone to ask you.
Yep, exactly. What about, and we get lots of questions, Ian, about B, which is, what do we need to have in our file to satisfy B? What would you say? So let's take a simple situation, and yes, you can't just jump over it, but let's take a higher risk situation, an elderly person with 3 kids. Okay. So let's say here we are, we have Margaret. Robert is now deceased. Margaret is, in her late 80s, and she has 3 kids. What are we going to ask her about her assets that is going to satisfy that, we think that she's capable of understanding the nature and extent of her property relative to the disposition?
Well, again, I like to try to think of it in terms of a process to make sure that I cover that properly. And the process is as often as most of us do on this call, and that is we create some sort of outreach, if we can, to create some data before they come in the room. So sending a questionnaire, sending something to send back to us with some of the basic parameters of their assets. Because of course, and nobody really likes to do that. And even at an elderly stage or if you're a young person, it's a pain in the neck. But what it does is it's my starting point to see if we're even in the ballpark of understanding the nature and extent of their assets. The case law is clear that you don't have to have granular knowledge, but you have to have good, solid knowledge. And certainly in this situation where you can identify, I mean, for sure, which bank accounts you have, your bond portfolio, things like that. Of course, some of those details aren't going to be readily available to the client. And so I will often say to them, well, look, this is the little bit of information we have. Who else can we get some more information from, like an accountant or an advisor? But I think people sometimes overplay that. In litigation, they certainly overplay it. They want to make a big deal out of this drafting solicitor who hasn't given you clear, identified assets and liabilities. And I don't think the cases support that. I don't think the courts support that, because if you think about it naturally, judges don't think, they're sitting around saying, I don't know what my RSP is at, and I don't really know what. And so there's a certain amount of litigators tend to overplay it. And at the same time, sometimes if you're too curt with that inquiry, then you've understated the importance of what is a foundational aspect of the test.
Are you concerned? Let's talk about the point you made about questionnaires. Do you get fussed about the fact that maybe, the client themselves hasn't filled in all of their assets? Does that concern you when they return it to you and then you're reviewing it with them and you can see that maybe they didn't fill that in? How do you rank that as far as concern goes?
Well, I think, and this is where, think like a lawyer. You have to delineate what they're not filling in. If they're missing a major asset of their portfolio and can't even give you a sense of what it is or where it's at in terms of value. For example, you've got the cottage there. If they don't have it down, and I haven't asked them if they have any recreational properties, but then if I see a large item, then that may create a red flag. I don't know. I mean, what do you find, Jordy, in your practice?
Yeah, I don't get that fussed about the fact that, a child filled in their list of assets. Because the reality is, the point is not whether they can, they can recite them. It's not a test. Can you tell me what you have in your bank account? The point is, when you look at this list, does this look right to you? And do you bank at CIBC or Royal or wherever? Do you have a cottage? Yeah, of course. That's the concern. I'm not concerned that they're getting the data, that they're not independently coming up with the data themselves. I think the question is, are they able to understand, right? Capable of understanding the nature and extent of their assets. So I think that's that. What do we mean by the third one, which is evaluating claims of people who might be expected to benefit? Tell me about that and how you're gonna question a client about that point.
Well, I take this as a teaching moment with the client, because most of the time the clients don't entirely understand this aspect of the test, because they don't actually see what they're doing. They're maybe dutifully giving some money to their kid who hasn't done as well as the other one, and won't see it as a potential source of a potential claim if you underpay that child on death, and by way of a succession law reform claim or something like that. So I'll often get into that aspect of the inquiry by directing their minds to the types of concerns the court might have with respect to any of your beneficiaries who might typically enjoy the bounty of your assets. And also, of course, I would jump all over it if I'm being told by a client that one of the children are being eliminated or something like that, something dramatic like that.
So let's take that situation. So here we have Margaret Grant, okay, and she comes to you with 3 kids, and she starts talking about the fact that she's only giving it to Franklin and Melissa and cutting out one of her other kids, the other kid. So obviously Rodney, it turns out, she's cutting out, okay, as you can sort of commiserate with. So she says to you, you know what, I'm here because I'm doing a will. I have I have a cottage, I bank. I don't really know that much about my banking. My daughter, Melissa, handles most of that for me. Have you talked to her yet? Can you ask her? You can ask her these questions. But yeah, no, Rodney, and we're not leaving anything to Rodney, she says to you. Okay. So how does that tie in to this issue about evaluating the claims from people?
Well, that's exactly the point when you say evaluating. I mean, we need to be able to, I like to anyway, with my clients, say to them, look, let me evaluate why you're doing that. And I need to document carefully why you're doing that. And I want to make sure that you understand the consequences of doing that, and that it is out of the norm, and that most judges will perceive this as out of the norm, and we better have a good reason for it. And I'm not a big fan, just as an aside, of putting those reasons in the will itself. But I'm a big fan of documenting it carefully and walking through the client their understanding of why. So many times when I challenge a will and an excluded beneficiary, whoever it is, maybe even someone who was a nephew in the prior will is excluded in the subsequent will, and there's no note, or there's just a, well, he's done well kind of reference in your notes. It's just fuel for the fire for me if I'm going after an attack on a will, for sure.
So, and the other thing about this is, I always ask when Margaret comes in and says to me, "Yeah, Rodney, I'm not giving anything to Rodney," and whatever the reason might be, okay, whether they're well off or they don't need it or they told me they don't want it or whatever, I always ask the same question: how do you think everyone's going to react to your will? And usually you get one of two answers. One is, well, I'll be dead, so I don't care. That's one we hear, right? And the other is, well, they might be upset, but or they're expecting it, or they should expect it, or whatever. So that question is another good question. If you're making notes of addressing that one, is why you're doing it. Obviously, that's the number one question. Tell me why. And then the second question is, how do you think people are going to react? That's important for them to have insight, right? Because at that point, that's when they're evaluating, right? They have to be capable of evaluating and these aren't claims necessarily in the typical legal sense. They're just the typical disposition, what people would expect in a normal situation, right?
Yeah, and I go one step further, and in lots of situations, I say, well, are you prepared to tell your child now what you're doing? And that, even the question creates an evaluating response. Yep. You know what I mean?
Yeah, no, for sure. And that really is, C and D are the ones that are the biggest. I mean, D is not in the original Banks and Goodfellow test, right? Banks and Goodfellow doesn't even ask the question of why, but it really is when at the end of the day, it's the only question that really matters. If a client has a clear and consistent rationale for making a decision, you're going to be in a much better position. And that's really where, and you tell me, and I mean, isn't that where you would, as a litigator, really drill down the why?
Yeah. And, this is a consequence of an article that Ken Schulman and I were involved in writing with a group of great authors. This was where the rubber hits the road and actually making Banks versus Goodfellow mean something in 2021. I really believe it, because the other elements of it are known and well entrenched since 1870. But this idea of a rationale, if you're going to analyze the matter at some later date by a judge or some does a retrospective opinion or something, the consistent rationale or the reason why articulated and documented at the time is really the TSN turning point in terms of capacity, because at that point in time, you are testing understanding nature and effect of the will. You are testing the nature and extent of property. You're testing capable of evaluating who should take all of the core elements of Banks and Goodfellow. But, and the credit goes to Ken Schulman on this D, because this was really something that he kept saying, we're missing this element of this part of the test being articulated. It was sort of assumed but this is clearly articulated. And I love that part of the D, and that language is, in my view, crucial to any testamentary capacity testing.
And what's crucial, of course, to be able to make this or check off this point is prior wills, right? So,
Yeah.
You got, I would have to see those prior wills before I can really test this, because, how do we know there's been a departure unless you go into that? And that's why, if you're using software, and eState is one of the first things it asks is, ask about prior wills, because it's so important to get to this rationale. And the idea of a consistent rationale is that you don't just, the client, we're here interviewing Margaret here, and, you ask, oh, you're cutting out Rodney? Yeah, I'm cutting out, we don't get along very well. And let's say you stop at that. Well, that's probably not enough, right? Because the question why. But the other point is that it's not just a one-time point, right? It's not, you ask it once and then assume it's correct and move on. Returning to that point is what I try to do in my interviews. So maybe if it comes out early in the meeting, I won't leave it alone, or I'll leave it alone for a while, but I will return to it on maybe 3 occasions. And I'll definitely return to it when we go to review the will and when we go to sign the will, to see that if that's a consistent rationale, which is, I think, important in the test here. Let's leave aside the mental disorder, including delusions, for a second. Is there any way that let's just drill down a little bit on D, because it's so important. What are your notes going to say about, so again, Rodney's getting cut out. Let's play out for a second how you might interview Margaret about that. What would you say there?
Well, look, I think there's a couple practical problems. Number one is I totally agree with you on the repeating the inquiry. And the notes need to articulate that. And if your notes are only sort of light on that, and those are the only 3 things you wrote down throughout the time you met with the client, I think it tends to underestimate your efforts, and I don't think it's a good idea. But secondly, this consistent rationale being proven, supported by prior will, is a tough practical problem, because most of the time when you have a new client, it is hard to get that prior will. They may not have a copy, it may be at the other lawyers. And so at the first inquiry, I'm not saying you give up, but in your first meeting, you may have to just take their word for it, that's what the prior will says. And I'll often go right into that and use the prior will information that they're giving me to help test their capacity. And use that as another part of the repeat inquiry in terms of trying to just get to the bottom of it. And the other point I will make in terms of consistency is that I will not shy away from the fact that this is going to be a problem. No matter how well I do this will be a problem. And that brings back to the evaluating, understanding. Ken Shulman talks about it. Like, when you talk to someone about creating a difficult situation on your death, there's some that just says, who cares, I'm dead. Most people's natural reaction is, geez, what am I doing? And they'll want to even give you more rationale and give you a more principled reason for why they're doing it. So teasing it out with just reminding them of that, it helps you from that standpoint, and it really helps at the back end on any inquiry when a lawyer's coming at you saying, what were you thinking? What were you doing? Why would you, what inquiries did you make with regard to this? You get to identify that not only did I explain all of that, I told the client this is going to be a problem, and they put their mind to that. And I just find that's another powerful step and another powerful tool.
So let's think of the situation where Rodney, the response from Margaret is that, oh, I don't see him anymore. What are the first things that come to your mind as far as obviously you're not going to just stop there. So what are you going to do as far as questions?
Well, these are sensitive moments in the meeting, and I always delicately say, well, look, again, you might not know why I'm asking this. This is why I'm asking it if I have to preface it. Or depending on the rapport I've got with the client, I'll just say, look, I need to understand what the estrangement is so that I can have a record of it in my file. And I will just, I mean, again, you know, I don't, nobody has a lot of, you know, nobody has endless amount of time, but when I get into a will drafting situation where I've got unique instructions, I just take a deep breath in myself and I look at my watch and say, I'm going to slow myself down. This is not going to be a typical intake. And I have to remind myself, because estrangement, fine. Oh, yeah, you had a fight at a wedding, fine. You know, no, wait a minute. You know, let's walk through this and understand it. And for the sake of the extra 5 minutes it takes to get the detail and the evaluation from out of that client, it will save you so much time at the other end of the day. You will be proudly looking at the lawyer across the table saying, yeah, you know what I did? And you know what I did next? And you know what I did after that? And I got a note of it. Right.
And so, you know, a timeline is important. That's how I sort of look at this. You know, first, obviously, some empathy. Oh, that's terrible. That must be stressful for you. Yes, it is. Well, tell me when did that happen, and how did it happen, and you know, and what's happened since, and when was the last time you spoke to them, and you know, those kinds of things. Establishing a time frame is important, and I think I mentioned this last week, especially in light of what the prior will says. If the estrangement predates the prior will and the prior will left things to that person, then an explanation of what, you know, oh, so what's changed since you did that will, and how has the relationship changed? I think those kinds of open-ended questions, you know, on this topic, and you can't, yeah, I mean, you really need to spend the extra time on documenting that.
So, and Jordy, just on that point, just looking at e-state, when you've got estrangement, you've got description, does the program only allow you to write 142 characters or something?
No, you can keep going. You can keep going. I mean,
I know, but
yeah,
that's important, because I don't want you to feel that you're restricted.
No, you're definitely not restricted. Take good notes. And before we adjourn for the day, and we have some questions which we'll get to if we can spend a few minutes after 1 o'clock, but I want to end around 1 o'clock. What do you have any views on, you know, we're talking about, and maybe we'll extend this to the next time, but the idea of remote, we're doing a lot of remote interviews now. Most of our interviews, at least speaking for myself, all my interviews, which, you know, are remote. Anything that we need to do differently for remote type meetings in a couple of minutes?
So I just a couple of quick points. First of all, remote is a curse for all counsel now. I mean, I've just come off a month-long trial trying to cross-examine witnesses in remote. It is a difficult tool. But it's the reality. So if it's the reality with will instructions, I am absolutely making certain who's in the room. I need, and I will ask my clients to do a camera span around the room if I need to. If I'm hearing background noise, if I'm hearing anything, I want to make sure that I can understand what's coming my way. And secondly, and lastly is I want to make sure they can get what I'm saying. And then I want to make sure my internet connection is solid, and that I'm reminding them that if they're not hearing anything I'm saying, or a crackle or it's frozen or something, please tell me. And that should go right on the Zoom call, and I record it, because it gives you a really important sort of baseline. So when I'm cross-examined on this, I can say, yeah, no, we were sure that no one was in the room, and I was sure that the communication back and forth was working.
So maybe what we'll do is talk about that at a subsequent capacity one, about special techniques that we can employ when we're taking instructions via remote involvement. Sure. I'm going to fire a few questions. We're going to end the formal part of the presentation, and we'll continue this again because there's so much more to talk about on this testing for capacity and things like that. But let me just see if there's a couple of questions here. Are you fussed in where a client is going back and forth on a certain decision? Maybe it's not even an important, a crucial beneficiary decision, but But let's say they're going back and forth on an executor. They say this person, then they change their mind. Then they go to this person. Then they go back to this person. I mean, how concerning are you on that? How concerned are you about that?
Well, it ties to what they're changing their mind on. But if it was what I would describe as an administrative matter of that nature, I don't get that concerned about it. And I do like the benefit of Zoom and all of the intake we do on Zoom now, because it's a lot easier to say to them, look, take a deep breath. We'll set up a call in 3 days, a week, and you can think over this and tell me. And if I have to do that 1 or 2 times, and I feel that there's a tone in their voice or an indecisiveness in their decision as a consequence of other reasons, then I get concerned. But I am generally not so concerned about this, because these are tough decisions for which many of these people have never had to make. Who's going to be my president of my estate, kind of thing.
How do you handle where you're asked the client why, and you get an answer that seems kind of unreasonable to you? Do you jump in there? What do you do?
So whenever I get into that situation, I always fall back on blame the judge, and I'll say, look, I hear you, but this isn't going to make sense to a judge. So you have to help me through this a little more carefully. I don't understand this. I don't understand that. All of us are capable of drilling down on a what would seem to be a improbable or bordering on irrational answer. And sometimes they just make sense. And sometimes I just want to give all my money to cats. But to leave it just hanging is, in my view, not a great idea. But as I say, I blame others. I just say, look, you can imagine what a judge might say, or I can say, look, there are cases where judges have said this doesn't make any sense, so I need more explanation.
Right. Lastly, what about prior wills? Do you always keep copies of those prior wills? And why is that a good idea or a bad idea?
So I'm actually, and especially with the digital age, I'm a big fan of just scanning prior wills. Some people will have a tearing ceremony and never see it again. The truth is, with metadata and ability to reconstruct hard drives and things like that, a prior will could almost always be found anyway. And so I just like to have it in an organized way. Even if the client is adamant that it not exist, I think that I make a note of that. I can explain why. I have never had a client actually say to me, I don't care, I still want you to know, I want nothing on the planet to show I have it. The truth is, if I've created it in my office, it's going to be almost impossible to get rid of it in any event. So I'm a big fan of keeping the prior wills. And if someone else did the will, I just scan it in and it's in the file.
Yeah, I don't think it, I would always keep a prior will for my own file. I want to know that I want to be able to say, yeah, we looked at it and the client rejected what they had done and wanted to make a change to it. As far as a will challenge goes, and you're back to a prior will, they're going to be able to find that prior will somewhere. So the fact that you don't have a copy, I don't think is going to preclude that possibility. And that's different than revoking it independently, right? So, which we can, I guess, address at another time. So one last question, and we're going to continue this, and maybe what we'll also have is a more of an open session where we can address a whole bunch more of these questions. But what about the idea where you're excluding? So Margaret here says, well, I have another family now, and I'm excluding my old family, my prior kids, or my kids from a prior relationship because of my ex's behavior and the family law dispute that we had. And so I don't think my kids should get anything. Is there anything different about that than any sort of other typical?
Yeah, I think, we can't forget testamentary freedom, and people have the right to do what they want with their assets within certain parameters. And again, if there's a rationale and it is evaluated in a sensible way by the client, that's a very different scenario. And if they weren't, say, if they're natural children, for example, but they were from a prior relationship, just think intuitively, I don't see that as something that would I mean, look, I'm not going to stop my inquiry, but I don't see it as, I will call that an orange flag, not a red flag.
Okay, good. So we would like to keep it to half an hour, so let's do that. There's still lots to talk about. Maybe we'll talk about why we don't put, or why you don't recommend putting the reason for exclusion in the will itself. We'll talk about whether you should leave $1 to a beneficiary who you're cutting out, and I'll cut to the chase and say don't, but we can discuss why we don't, and a whole bunch more in the coming weeks. And so thank you all for joining us today, and hope to see you again next week. Bye-bye now.
Thanks a lot.